Hi, friends. So this is an impromptu live. I just checked the court docket in Donna Adelson's case, and I wanted to bring you the latest document that has been filed. So I wanted to share it here right now and go over it, read it real quick for you. This is going to be super duper short because I have to go pick up my son soon. But hopefully most people will be able to catch this on the replay. But if you're here, give me a whoop whoop, because Donna is not having a good time, you guys. As Judge Everett said in the hearing last week, jail is not fun. And you know what else is not fun? Losing motions. Losing motions is not fun. Listen, I don't know what Dan Rashbaum has told Donna Adelson. Maybe that the forces of Tallahassee are all against him, are all against her. He doesn't know what's going on. Listen, I don't know. But at this moment, she can't be doing well at all. And this comes before the day before a hearing, a big hearing on her motion in limine regarding Sergeant Chris Corbett and his testimony about communications analysis and the state's summary evidence, right? So they're probably going into the hearing tomorrow thinking, you know, we're gonna rally from all the denials of our motions last week. But listen, the hits keep coming. Let me share my screen with you guys real quick and go over this. Again, this is going to be a real quick live. This is going to be a quick live. Let me say hey to Worldwide Collaborations. Hey, shout out to you. You are the first to jump on this live with me. So appreciate you joining, and I appreciate everybody else joining. This is what's going on. We just got this order denying Donna's motion to dismiss the indictment for pre-indictment delay or alternatively to exclude evidence. Let's get into it right now. All right. I can straighten it up. Okay. This cause came before the court upon defendant's motion to dismiss the indictment for pre-indictment delay or alternatively to exclude evidence pursuant to Florida Rule of Criminal Procedure 3.10 and the Due Process Clause filed on August 12, 2024. The court, having considered this motion, having reviewed the record and being otherwise fully advised, hereby finds as follows. The defendant argues that because of the more than 9-year delay, you guys, between the date of the alleged offense and the issuance of the indictment should be dismissed. In the alternative, the defendant argues that certain call pattern and text message evidence that she cannot adequately address or refute should be excluded from being admitted at her trial. Dismissal. The primary relief defendant requests is dismissal of her indictment pursuant to Florida Rules of Criminal Procedure 3.190. As an initial matter, the court finds that defendant's motion to dismiss is untimely. The rules state, unless the court grants further time, the defendant shall move to dismiss the indictment or information either before or at arraignment. However, to the extent due process requires the court to consider defendant's motion, the court will analyze the merits of the claim. In order for an indictment to be dismissed because of pre-indictment delay, defendant must meet 2 prongs. We heard about these prongs in the hearing. First, defendant must show substantial prejudice. Second, defendant must show the state was operating under bad faith when it delayed seeking an indictment. Based on the record evidence, this court finds defendant does not satisfy the applicable standard. Defendant failed to demonstrate substantial prejudice has resulted from her inability to procure certain records. And that's quoting State versus Hope. The prejudice must amount to a material impairment of a defendant's capacity to prepare a defense. Considering all other admissible evidence connecting the defendant to the charged offenses, the court cannot conclude that the cell phone and SunPass records, if preserved, would have been exculpatory per se. Thus, a material impairment of the defendant's capacity to prepare a defense does not exist. Defendant also failed to demonstrate the delay was the product of bad faith by the state. Indeed, no record evidence indicates that delay was caused by, quote, bad faith on the part of the state. In other words, there is simply no evidence in the record that the length of time from the murder to the indictment was the product of bad faith on the part of the state. See a case, Fleming versus State, which says there is simply no basis in the record for concluding that the delay on the part of the state could have or should have been avoided. It appears rather that the case was simply a difficult one for the police and prosecutors to resolve. Moreover, Catherine McBanois' testimony during Charles Adelson's trial revealed new information that the state was not previously privy to. Thus, by the way, if you see up here, this order is 111 pages. When I initially saw that, I was like, what? It's so long because it attaches trial transcript, okay? Which I'm not going to go through today. We all watched the trial, right? Thus, the court cannot conclude the state was acting in bad faith when it learned new and significant inculpatory details in 2023 about the evidence in this case. If you'll recall, at the hearing last week, the judge wanted to go back and review the testimony of Katie McBanois to see if it, in fact, was the first time that she was testifying about certain things. The reason for the delay, the state said, was because they were just learning information from Katie McBanois, okay? And that's actually, I think, the reason why they said that they did not pursue SunPass records of the Adelsons, because they didn't connect those dots before. Katie had not spoken about that in any context or any way to let them know that, you know, it could have been something for them to follow up on. Back to the order. In addition, the United States Supreme Court has previously held that the Due Process Clause does not permit courts to abort criminal prosecutions simply because they disagree with a prosecutor's judgment as to when to seek an indictment. Here, the court concludes the delay did not violate fundamental concepts of justice. Rather, any prejudice which defendant may have suffered is counterbalanced by the state's need to finish its investigation into the defendant's alleged involvement in the charged offenses. And that's quoting two cases, the Marrero versus State and also the Levasco case, which state prosecutors are under no duty to file charges as soon as possible, cause exists, as soon as probable cause exists, but before they are satisfied, they will be able to establish the suspect's guilt beyond a reasonable doubt. See also Overton, which states the pre-indictment delay of 5 years was not caused by any law enforcement wrongdoing, but instead resulted from the multiple other leads and suspects that were pursued. Accordingly, defendant's motion to dismiss is denied. Exclusion. As alternative relief to dismissal, defendant seeks to preclude the state from introducing exhibits or testimony at trial that she cannot adequately refute because of the charging delay. Section 90.403 Florida statutes provides that, inter alia, which means among other things, relevant evidence is inadmissible if its probative value is substantially outweighed by the danger of unfair prejudice. The party seeking to exclude evidence on the basis it is unfairly prejudicial carries the burden. Additionally, in order for relevant probative evidence to be deemed unfairly prejudicial, it must go beyond the inherent prejudice associated with any relevant evidence. Again, just as with her motion to dismiss, defendant Donna has failed to establish that the probative value of the evidence she seeks to exclude is substantially outweighed by the danger of unfair prejudice. The evidence is relevant and probative, and defendants' concerns, quote, go to factual issues involving the weight of the evidence rather than its admissibility, and as such are for the fact finder to resolve, close quote. Nor does the prejudicial effect go beyond the inherent prejudice associated with any relevant evidence. Defendant will be able to cross-examine the state's witnesses to ameliorate any prejudice caused by the absence of the records she claims are necessary to refute the state's theories. And that's referring to the Torres case, in which defense counsel was able to cross-examine the relevant witness and elicit testimony to impugn the evidence's reliability. That's why we have a finder of fact, to determine the reliability of evidence and the reliability of witnesses. Accordingly, defendant's motion to exclude evidence is also denied. Wherefore, it is ordered and adjudged that defendant's motion to dismiss indictment for pre-indictment delay or alternatively to exclude evidence is hereby denied. Done and ordered in Leon County, Florida, on this 5th day of September, 2024. Stephen Everett. Yes. What say you? This is new. This is brand new as of this afternoon. Let me get to some comments really quickly. Let me get to some comments real quick because this is going to be a very quick live stream. I have to go pick up my son soon. Hey, Top Cat. You always find me, don't you? Hey, hey. Yes, indeed. This is a big one. Love Judge Everett. She's going to be found guilty. I mean, things are not looking good for her at all. Not at all. Between this hearing, or between this motion to dismiss the indictment, and all of her motions that were denied last week, things are not looking good for Donna. There's another hearing tomorrow morning. I will be live streaming that hearing. I just set up the live stream in StreamYard, so I hope to see all you good folks again in the morning. There is a motion in limine to try and prevent Sergeant Corbett from testifying as an expert witness, and also to try and dismantle the state's summary evidence that they've put together. I have a video right now that I'm trying to download. It's taking forever. It's taking forever, y'all. Anyway, hopefully we'll be able to watch it tonight. Going through that motion, reading through that motion, just so that we're prepared for it in the morning. So I don't know. I hope to get it uploaded at least by 7 o'clock, but this thing is taking forever. Technology, right? Let's see. Tennis Girl 101. Is this new? It's brand new. Hot off the presses. Yes, it is. It sure is. Welcome, you guys. Denied. Hi, Helen. Hello. Hello. Yes. Check it out. Check it out. The order is straightforward, to the point. It's succinct. It is 111 pages. Let me just show you guys real quick. It's 111 pages, but that's because they include a trial transcript. I guess this is from October 30th, 2023. So this is from Charlie Adelson's trial, but this must be the day that, that Katie McBanois testified. So it includes all of that. The order itself, I think, is what, 5 pages maybe? Yeah, they included the entire day's transcript, but the order itself is 4 pages. So that's why I was able to get on and read it. I'm definitely not going through the entire transcript. Hi, Penelope Ray. Hello, hello. Hi, Riverdale Pilates. Yes, yes. The motion to dismiss was denied. I mean, I had a feeling that it was going to be denied, but Judge Everett wanted to go back and review the trial transcript from the day that Katie testified. He did that. He attached the transcript to his order denying the defendant's motion to dismiss the indictment based on the indictment coming 9 years after the killing of Daniel Markel. And he also dismissed their request to exclude evidence, the SunPass evidence and the text message. I think it's the text message from Donna to Charlie on the night that Danny passed, where she's saying outside your house and he's responding, all right, I'll be there in 10 minutes or something like that. So those will be coming in. Those will be coming in. Hi, Angela. Thanks for joining. Top Cat's asking, did it say they were too late filing this motion? Yes, indeed. Let me show you that. And this was not even raised by the state. Just on that ground by itself, he could have denied the entire thing. But yes, as an initial matter, the court finds that defendant's motion to dismiss is untimely. So the Florida Rule of Criminal Procedure 3.190C says unless a court grants further time, which it did not, the defendant shall move to dismiss the indictment or information either before or at arraignment, which was months ago. So surprisingly, the state didn't raise that as one of their grounds, but the court was on top of that. I'm telling you, Judge Everett, he is on top of things. Hi, Lori Woodman. What time is the hearing tomorrow morning, please? And thank you. 9 o'clock. I believe my stream is starting at 8:50 or 8:55. So I hope to see you there. Hi to Kinsella. Thanks for joining. Thank you for joining. Donna's motion to dismiss has been denied. It was denied. Denied. What is she feeling? What is she feeling this evening, this early evening, huh? Not good. Hi, Gigi. The hearing is at 9. The hearing is at 9. Let me just check the docket really quick. Okay. So you guys see this? Oops. Yeah, this motion hearing right here, 9/6, 9 o'clock. All right. Let's see. Stale. They were saying it was stale because it had been 9 years since the event in question before she was indicted. Yeah. I mean, I think they're just throwing things out and seeing, maybe they'll get lucky. Maybe something will stick. It seems like that's what they've been doing. They've been throwing things out, including things that, similar motions, basically same motions that were put forward in Charlie Adelson's trial that were denied. They're doing it again, trying it again, and trying to, explain that, maybe this is a little different this time because, X, Y, or Z reason, but they're not getting very far with it. I'll see you in the morning, Lori. Angela's asking, do I have an opinion guess on whether Weinstein's subpoena quash will be denied? No, I don't. I don't. What was that based on? The fact that he's saying anything that he would testify about is privileged? I think that's what I read. I think that's what I read, but I've had a lot of other things going on since. Honestly, I don't know. I don't know, and I don't know when that motion is going to be heard either. So that's up for grabs. I'm not educated enough um, on the basis of it, or even who he was to have an opinion at this point in time. T. Consol, I could be crazy, but I wonder if Charlie will ally with Mom and Rash against Wendy. Not tell the full truth, but throw Wendy under the bus to attempt to make Donna look more innocent. I mean, I wouldn't call you crazy for wondering that. I mean, I think we've all kind of wondered whether or not something like that could happen, right? I certainly have. We've kind of run through all the scenarios already. So we'll see. We'll just have to see what happens. I wonder if Donna will give Rashi a score 95. I don't know, but I don't like how that sounds. I don't like how that sounds. All right. Put a 1 in the chat if you're going to be watching the hearing tomorrow morning. Put a 1 in the chat if you're going to be watching the hearing tomorrow. It's Friday. And hopefully it'll be the start of a wonderful day. And I hope that Judge Everett rules from the bench. Yes, we have Gigi, we have Maui Swift. Hey, I don't think I've seen you in a couple videos, I guess. Angela, yes. Jesus Lover, yes, yes, yes. Turquoise Kitten. Shout out to all of you. Lori Woodman, Worldwide Collaborations, who was the first commenter, first person to jump in the chat today. Big ups to you. Tennis Girl 101. Of course, Top Cat 88. Appreciate you always being here, so always supporting. T. So my hands are busy. I'll watch. Trish Norman. Hey, yes. No worries, Maui Swift. It's good to see you today. It's good to see you today. All right, you guys, I have to run. I have to go pick up my son. So I hope that this is a little bit of good news for all of you today. This is one more step in favor of justice for Dan, right? So we've like conquered one more thing on the road to justice for Dan. I have a feeling this is not going to be the end of it. We're going to see what happens in the hearing. Donna's trial will start soon thereafter. We're like 2 weeks away now, I think. But it's not looking good for her. It's not looking good for them right now. All right, you guys, I got to run. Have a wonderful evening. I'll see you in the morning. All right. Good night. Sleep tight. Don't let the bed bugs bite. That's what I say to my son. All right. Bye, guys.